Good morning, everyone, and welcome. I now call to order the meeting of the Michigan Civil Rights Commission. Today is Monday, April 29th, 2024. The time is 10:06. Will the clerk please call the roll?
Commissioner Lara,
Present.
Commissioner Worthams,
Here.
Commissioner Londo,
Here.
Commissioner Barker,
Present.
Commissioner Corvo, Commissioner El Hassan,
Present.
Commissioner Gasco,
Here.
Commissioner Roberson.
Albeit a few minutes late, present. Sorry about that.
Madam Chair, you have a quorum.
Thank you, Attorney Satchel. Moving on to Agenda Item 2, Approval of Meeting Agenda. My fellow commissioners, is there a motion to approve or amend the agenda?
Madam Chair?
Is there a second?
Second.
A motion has been made by Commissioner Londo, and we have support from Commissioner Worthams. Is there any discussion? All in favor of the motion to approve the agenda as submitted, say aye.
Aye.
Opposed? The motion carries unanimously and the agenda is approved. Good morning once again and welcome to the meeting of the Michigan Civil Rights Commission. We thank you for having us here in the John Fetzer Center on the campus of Western Michigan University in Kalamazoo. Before we continue with our opening matters agenda, I will ask our General Counsel and Special Advisor Lamont Satchel to provide the role and authority of the Commission for our audience. Attorney Satchel, you have the floor.
Thank you, Madam Chair. The Michigan Civil Rights Commission was created by the Michigan Constitution in 1963 to safeguard constitutional and legal guarantees against discrimination. The Commission is charged with investigating alleged discrimination against any person because of religion, race, color, or national origin, genetic information, sex, including sexual orientation and gender identification, age, marital status, height, weight, arrest record, and physical and mental disability. The Michigan Department of Civil Rights was created in 1965 and serves as the operational arm of the Commission. Passage of the Elliott Larson Civil Rights Act and the Persons with Disabilities Civil Rights Act in 1976 further clarified specific protections guaranteed under Michigan law. Thank you, Madam Chair.
Thank you, Attorney Satchel. Moving on to item B, recognition of significant observances in April. There are several significant observances during the month of April relevant to civil rights, and we would like to recognize the following. On April 4th, 1968, Dr. Martin Luther King Jr. was assassinated on the balcony of his hotel room in Memphis, Tennessee, while preparing for a march in support of the city's striking sanitation workers. 1 week later, on April 11, 1968, President Johnson signed the Civil Rights Act of 1968, also known as the Fair Housing Act, providing equal housing opportunity regardless of race, religion, or national origin. We also observed during the month of April National Fair Housing Month, Deaf History Month, World Autism Awareness Month, and Arab American and Chaldean American Heritage Month. Moving on to item C, Public Comment Protocol. We will have Patricia Barrera, who is representing Deputy Director Kim Woolridge, to please come forward to provide the protocol for public comment. Good morning, Ms. Barrera, and thank you for joining us today. You have the floor.
Thank you, Chair Lara. Good morning. Again, Chair Lara, Commissioners, Director Johnson, and Attorney Satchel. My name is Patricia Barrera, and I'm the Strategic Initiatives Coordinator for the Michigan Department of Civil Rights. There will be 2 opportunities to provide public comment during today's meeting. If attendees wish to speak during the public comment portion of the agenda, you must sign up to do so within the next 10 minutes by completing a public comment form. If you require assistance, please notify a MDCR staff member at the sign-in table. When it's time for public comment, Chair Lara will call on attendees in the order in which we receive their request to speak. The public comment time frame for speaking will be 3 minutes. There will be a visual timer showing the following colors: green for 3 minutes, yellow for 30 seconds, and red for stop. The timekeeper will verbally remind each speaker when 30 seconds remain. Please also be aware that MDCR staff will verbally warn any speakers only once if they use inappropriate, inflammatory, or disrespectful language. If use of that language continues, the speaker will be asked to stop commenting. That completes the public comment protocol. And Chair Lara, I turn the meeting back over to you.
Thank you, Ms. Barrera. The next agenda item is adoption of the consent agenda. The following items from the agenda have been identified as those that may not require commission discussion prior to being adopted or received. Items may be removed from the consent agenda on the request of any commission member. Items not removed will then be moved for adoption by general consent without debate. Removed items will be taken up later in the agenda as indicated. For this meeting, Harold Kaur and Liliana Stoneback have been removed from the consent agenda and will be reporting out on the activity of the Special Projects Director and the Fund Development Coordinator. Is there a motion to adopt the consent agenda?
So moved.
A motion has been made by Commissioner El Hassan and supported from Commissioner Worthams. Is there any discussion? All in favor of the motion to adopt the consent agenda as submitted, say aye.
Aye.
Opposed? The motion carries unanimously and the consent agenda is adopted. Our next agenda item is approval of minutes. We have received and reviewed the draft minutes from the January 22nd, 2024 meeting. Is there a motion to approve the minutes as submitted?
Madam Chair.
A motion has been made by Commissioner Worthams. Is there a second?
Support.
We have support from Commissioner Roberson. Is there any discussion or revisions to the minutes? All in favor of the motion to approve the January 22nd minutes, say aye.
Aye.
Opposed? The motion carries unanimously and the January 22nd minutes are approved. Our next agenda item is public comment. Again, if our audience would like to give public comment, please complete one of the gold forms made available at the registration table. Ms. Sanford will collect the forms. As a reminder, we will be taking comments in the order received. You will have 3 minutes to speak before the commission. Please note our timekeeper is Patricia Barrera. Ms. Sanford, have we received all the forms?
Madam Chair, there are no public comment forms at this time.
Thank you. We will have another opportunity towards the end of the meeting for public comment. Our next agenda item is division and other reports. We will start with our Executive Director, Attorney John E. Johnson, Jr. Good morning, Director Johnson. We have received your written report, and you have the floor.
Good morning, Madam Chair. Good morning, Commissioners. Thank you for this opportunity to present on behalf of the Department. I want to start out by certainly thanking everyone who works for the Department, 144 staff members now, and the hard work that they have they have partaken in during the last quarter, as reflected in the division reports, and certainly I'll highlight some of those achievements during my report this morning. I begin, as I always do, with personnel changes. Listing them in terms of departures, promotions, and then new hires. I just wanted to make note of one departure, that is Melissa Kieswetter, who was our tribal liaison. She has transferred over to MyLeap effective March 18th as part of the governor's reorganization. She went over there along with the Michigan Tuition Waiver Program. From that position, she also will continue to manage the Native American boarding school study along with Alfredo Hernandez Corzin, the director by DEI department. So she will still be involved in that, as our department is we're still responsible for that report. So the money's still flowing through. As a matter of fact, Melissa's still on our payroll through the end of the fiscal year. So she technically is still an employee of the department, but she's working through MyLeap. So that is, again, a significant departure for us. Alfredo will assume the duties of the tribal liaison through the end of the fiscal year right now. However, we are looking for, continue to look for a community engagement specialist for the northern part of Michigan, and that person may assume the duties of the tribal liaison through the end of the year if we can locate someone. That has been a problem in terms of getting someone to apply for that position. So certainly Commissioner Gasco, if there's anyone who you know might be interested in applying for that, we certainly would like to know that. But again, so thinking about combining that position, so that way that person who's engaged in community engagement up there would also be the tribal liaison, which is probably where that position should be anyway, because it is part of the community engagement work of the department. So that's what we're looking at in terms of some reorganization going forward. New hires, just want to note, we have added a significant amount of personnel. As I mentioned earlier, we are currently at 144 staff members. 24 staff members were been hired in the past during the 3-month period in which I'm reporting, 11 of those being investigators. But you'll see a number of people who have been hired and 2 people who have been promoted within the department to positions. So we're pleased with those advancements and with those folks who have been promoted and those who have joined our family. Some have been transferred from other departments, and others have been new hires. Again, that's detailed in my report here. In other personnel issues, when I began 3 years ago, I had one-on-ones with the staffs just to get a sense of what they thought about the agency, some things they wanted to see changed, what we could do in order to improve their working environment, their conditions. I'm looping back now. Part of the process, by the way, new hire process, we went through and did an entire new onboarding process. I want to thank Tony Lewis of our community engagement division, who brought everybody together, put together a new onboarding process. One of the pieces of that process will be for me to meet one-on-one with every new staff member when they're hired, within a week or so of their hire. So I'm doing that, but I'm also going back and having one-on-ones with all the staff who I talked to 3 years ago, just to get a sense of what they think of where we are, and again, getting some tips on how we can further improve our process, our work, and their work environment. It's been very interesting. I've gotten a lot of good information, which certainly I'm passing on to the division chiefs, which is relevant. But again, that's been very enlightening to go back and talk to folks 3 years later. Budget update, again, you've seen this information already, focusing on the current fiscal year 24, in terms of, and you see that as we detailed it before, what we have received in terms of funding for this year. We want to indicate, though, that in terms of first quarter expenditures, we only spent $3.7 million of $23.7 million. So I certainly was concerned about that. We don't want anything to lapse. Had lots of discussions with our finance director, who assures me, and it's gone up with these. He said, "Oh, no, don't worry. It'll go up with each quarter. Don't worry." So he's already shown me where the numbers have increased for for this quarter and will continue to increase. So he's monitoring that to make sure that we do not have any money that lapsed. That's our goal, has been, and we expect to report the same this year. You see, again, the ongoing funding there as outlined in fiscal year 2024, one-time funding, which totals over $6 million in terms of money we have just to spend one time. There's ongoing versus one-time money, and then ongoing work projects totaling $6.2 million. Again, that represents monies that were left over from previous fiscal years, which we turned into work projects. And you see the various work projects that are listed there that encompasses that $6.2 million. Some of those have different lives attached to them. Usually they're 4-year in terms of their life. You'll see each of the fiscal years in which those work projects were approved. So you'll see that time is running out on some of these because some of them were approved in fiscal year 24, which was my first year here. So we're splitting up the training money, we're splitting up the CRIS money, et cetera, because those are about to expire. Fiscal year 25 coming up, and we submitted, I think we reported several proposals for change. Only one was recommended by the governor, which would be an increase of $5 million to our enforcement division budget. 29 total FTEs, 27 for enforcement, 22 more for finance and budget and finance and management services, so they can service the additional employees. Our proposal was for 5. The governor's recommendation was for 5. However, the House last week came back with a recommendation of only 2. I've already read articles indicate that they're already balking on some of the proposals by the governor. We'll see where that lands. As you recall, last year, you may not recall, but I'm going to refresh your recollection. Last year, the House took away all of our ongoing money and substituted with one-time money. The Senate reduced the one-time money significantly. We wound up getting exactly what we asked for. Not to say we will this time, but I'm just saying this is the beginning of the process. And last year this time I was visibly shaken to some degree by what came out. But I was assured by my finance director, oh, this is just the beginning of the word, and he was correct. So I'm not shaking this time, just sort of taking it in stride, and we'll see what happens with the Senate, and then certainly we'll see what happens once there's a conference and we wind up on with some final numbers. That's where we are. Enforcement, again, I urge you to read the division report submitted by Attorney Trevino, but just to bring you up to date, our EOC federal contract, we're required to complete 668 cases through the end of August, because we have to use 1 month in order to make sure, to do the paperwork, make sure everything's final. As of, I think as of this date, we have over 479 already completed. So we're well on our way to fulfilling that contract. Same thing with our HUD contract. Currently, we have 114 cases that have been closed. We've doubled that staff over the past few years. That's why they're able they're keeping up with the intake of cases. Our complaints have risen. They're averaging now 708 cases a month. They were 500 and something when I first started 3 years ago. So now they're up to 708, and I'm sure that's based upon obviously our increased activity, visibility, and then certainly the amendments to ELCRA that have been passed that have resulted in some increased intake and publicity surrounding those. Our current case inventory, we have over 3,000 cases, which is more than we've ever had in terms of our intake. We were lowering on the back end, but increasing on the front end. In other words, the old cases are being cleaned up, but we're getting more new cases. So in order to do that, we've certainly increased our intake staff, but just wanted you to know that those are increasing, so the extra money that we receive will come in handy because we have seen an increase. I think we reported earlier in terms of the one-time money, we're looking at a couple of things with that, engaging in an agreement with the alternative dispute resolution folk to move some cases out of the department into alternative dispute resolution. That's about 1,300 cases that we hopefully can move out of our system and over there. So we're looking at that. And in terms of, and then we started our mediation also. That was part of fiscal year '24 money. So we're having more mediations going on, again, trying to resolve matters to prevent lengthy investigations. Legislative report, there's a perinatal package which has been introduced in the Senate. I've detailed that here. It requires us to do a few things in that bill, which is basically receiving reports, having a toll-free line, and some of this we've met with the senator's office indicating that it's really, we feel it's beyond the scope of the work that we do right now. Well, you know, we investigate complaints of discrimination, so we're working with the office, with the senator's office on that to see if we can articulate, perhaps move a change in that in terms of who might be responsible for that reporting. We feel it's a better place with the Department of Health and Human Services as opposed to our department. Certainly, we're charged with investigating any complaints of discrimination which may result from these reports, and certainly we're ready to do that. But in terms of actually receiving them, reporting on them, and all of that, we feel as if it's something that's without, outside of our expertise and probably can be better done by another agency. Also, there's a pay equity bill that's been introduced. We also have discussed, we're going to discuss that with the sponsors. That does involve us in terms of investigating abuses of this act. And so, once again, it's an expansion of the ELCRA, and anytime legislation expands the LA Larger Civil Rights Act, we want to be involved in articulating how it may affect our operation. So they've been very open to us discussing this bill with them, so we're in the process of doing that also. Want to mention again our Civil Rights Summit. Go back to the legislative report. HB 4878, which has been introduced by Representative Ayash, which is basically a ban-the-box legislation for landlords, preventing them from asking about, in some instances, about arrest and conviction records. That's certainly under study by our department and was expressed as a concern that it be passed by a number of people last night at the commission hearing in Grand Rapids. So that is a bill of which we're aware, and we are looking at that and certainly working with the lead sponsors on that in terms of how that affects some of our protected classes. Speaking of the housing hearing last night, again, moving into our summit, you'll hear more about that from Harold Core, who'll be reporting on that, our special projects director, who will give you a full details on where we are on that, but that's scheduled for June 12th in Detroit. Also, fund development, you'll hear from Liliana Stoneback later on in this meeting, right after me, as a matter of fact. We're very pleased with some of the work that she's been able to pull together for us. She'll report on that in a few minutes. And I mentioned earlier, the Native American boarding school study is still in full effect. We're working with the contractor, Kaufman and Associates. They're beginning to reach out to the tribes, beginning to pull together what they envision to be their outline of what the report will be. So we're looking forward to continue to work with them. I believe that ends my, one more other thing which is not on here. We're in the final throes of putting together, I might have mentioned this at an earlier meeting, what we've called our white paper, which is with the foundation of what we want to be our next strategic plan, which we'll bring before you in July. We've had each division report on where they are and where they like to be in terms of their vision. We put all that together. We've introduced that on a very broad basis to our staff. We intend to engage in discussions with them over the next few months in order to put some meat on these bones, looking mainly at infrastructure, our processes, where we want to be in the next 4 or 5 years in terms of being paperless, et cetera, et cetera. And then in terms of just some overall look at where we want to go in terms of some of our work. Certainly, we have some money set aside for disparate impact work. We want to look at where we want to go with that. Not necessarily in terms of a subject, but certainly how we want to structure that unit so that it is prepared to deal with disparate impact matters. So we'll be coming before you in July with hopefully will be a finished product in terms of our white paper, our strategic plan for you to review and certainly comment on and eventually bless so we can go forward. That's into my report, Madam Chair.
Thank you, Director Johnson, for your report. Commissioners, are there any questions? Seeing none, we will move on to the next agenda item, General Counsel Report from Attorney Lamont Satchel. Good morning, Mr. Satchel. We have received your written report, and you have the floor.
Thank you, Madam Chair, Commissioners. I have 3 items to report on. The first deals with our recent comprehensive review of an amendment to our internal processes, which includes the commission rules. As you know, last year we made some amendments to the commission rules, and then this year determined that as we look through not only the commission rules but other policies that we had, that it was appropriate for us to make some changes. So we took another look at the rules with respect to other internal processes that we had that needed to be amended, and took another comprehensive review of our internal commission rules. We have completed the process for making amendments to those rules. We've gone through all of the rules, made some significant changes, particularly as it relates. A lot of them are just formality changes, grammatical changes. We made maybe 2 or 3 very substantive changes, which will be discussed later as we ask this commission to adopt those changes to the rules. The other item is the dynamic character legislation. The commission will recall back in October of 2023, you approved a resolution which confirmed your understanding of the legal issues inherent in the dynamic character legislation and affirmed your decision to refrain from implementing those requirements of the legislation because of the legal implications of it. In discussions with the Michigan Department of Transportation, that department had agreed to pursue the legislative adoption of proposed legislation that would correct the legal deficiencies that were identified in the dynamic character legislation and would make MDOT responsible for the requirements of implementing any dynamic character objectives and requirements as opposed to the commission. The proposed legislation was prepared and was reviewed by both the Legislative Services Bureau and MDOT. And as of today, MDOT has taken the lead on obtaining the legislative sponsorship of this new legislation and has been in discussion with prospective legislative sponsors for the legislation. It's my understanding that they're very close to getting it before the appropriate committee to have them review and pass the legislation. The last item, Madam Chair and Commissioners, relates to our request, a proposed department request that the commission seek an amendment to ELCRA to allow the commission to conduct its business virtually. Madam Chair, I would like to just briefly read from the memo that I prepared, because I think this is a very important matter, an issue that the public should hear, those that are present today and those that may later hear this recording, because of the implications of what we're asking. In response to the COVID-19 crisis of 2019, the state of Michigan initiated several processes to allow for the optimal operation of local and state government. This included an amendment to the Open Meetings Act to temporarily allow public boards and commissions to conduct and attend meetings virtually. With the expiration of this exception and resumption of the Open Meetings Act requirement for in-person meetings, it became apparent to many public bodies that formerly operated under the OMA exception that remote meetings were very efficient and effective means of executing their public duties and allowed for greater public participation and transparency. The scope and nature of this commission's civil rights work is broad in its jurisdiction statewide. The importance of the commission's work is evidenced by its constitutional creation and mandate, and necessarily requires that it reaches into every community within the state. This level of exposure can best be facilitated by providing an avenue that provides the greatest opportunity for the public to view and participate in the commission's work. Virtual meetings provide this opportunity in a way that in-person meetings cannot accomplish. The Open Meetings Act, at the time of passage almost half a century ago, in 1976, provided the then most modern and efficient way for public bodies to provide for transparency required in an efficiently functioning democracy, in-person public meetings. Availing itself of the technological advances of the 21st century allows this commission to greatly improve upon and accomplish the goals of the Open Meetings Act, while at the same time disseminating and promoting its work, civil rights protections, and constitutional investigation mandate to the greater Michigan community. Therefore, the department is requesting that the commission, like some other sister state bodies, including the Michigan Strategic Fund, the Human Trafficking Commission, the State of Michigan Retirement Board, and the Financial Review Commission, in addition to certain agricultural commodity groups, secure a legislative amendment to its governing operational legislation, the Elliott-Larsen Civil Rights Act, to allow for virtual meetings. This matter will be formally taken up during the new business portion of the commission meeting. Thank you, Madam Chair. That completes my report.
Thank you, Attorney Satchel, for your report. Commissioners, are there any questions? Seeing none, we will move on to the next agenda item. Special Projects Report by Harold Corr, who serves as the Special Projects Director. Good morning, Mr. Corr, and thank you for joining us today. We have received your written report, and you have the floor.
Good morning, Commissioners. Again, Special Projects Director Harold Corr. I handle pretty much things that are outside of the normal divisions within the department, so that's events and reports and other kinds of special assignments. Last year, the director talked about creating a series of fair housing hearings around the state. The point being to get firsthand testimony from people. And I know he talked about this a little already, but the idea being to get firsthand testimony from people and expert witnesses. We did have the 4 hearings around the state. We were able to gather about 8 hours of testimony in total. So that provides us with some good examples of life stories and the impacts of housing discrimination. And it also allows us to, it also allowed us to get some expert testimony that can help us with the recommendations, as the director mentioned. I did want to share a couple of examples of some things that we heard repeatedly. Director talked about the, I think maybe that was Lamont that talked about the criminal history, discrimination in housing and how that impacts people. I think it was also interesting to hear as well the way that it impacted the families and the children, not just the actual person who is the returning citizen. We also heard some stories about landlords wanting 2 to 3 times the rent, 2 to 3 times in income so that they know that you can afford the rent. That, in some cases, created a disparate impact against people based on age and then also potentially based on disabilities because they were on a fixed income. We also heard a number of testimonies about various elements of tensions between landlords and tenants in terms of accommodations to disabilities, including modifications to the internal portions of the apartment and other kinds of things of that nature. So I did want to kind of share those out kind of tease those out real quick. Going on to the summit, we do have a flyer that is on the website now. It goes through the morning and afternoon agenda, just to kind of give a feeling as to the day, of the structure of the day. We'll be starting at about 9, actually serving I believe a continental breakfast, and then starting about 9. The opening speaker will be Lisa Rice from the National Fair Housing Alliance. She will provide a keynote speech, and then she will join a panel discussion that's focused around artificial intelligence and housing equity. Following that will be a series of workshops, the first being a state of fair housing in Michigan, which We'll provide some data and other examples to kind of give a sort of a benchmark as to where the state is now in terms of fair housing. We also have sessions on environmental justice, rental aspects of real estate, and a legal updates panel. We've also, just so you know, we've kind of separated out some tracks, one being for organizations or people that are interested in enforcement kind of actions, and then also one for people that are coming to this event from the real estate industry. So that allows people to kind of find the workshops that they're most interested in, and also to invite them, you know, for the real estate industry, for example, if we're offering sessions that are specific to them, they're more likely to sign up and actually attend the summit. Excuse me, the lunch panel is on disability accommodations, and it's specifically on unleashing the facts of assistance animals. The afternoon breakouts, there's a state resources, recommendations, and policy solutions panel that will be composed of other state departments, and basically it will be an opportunity for them to talk about the resources that they can offer to people and any ideas they have for addressing or moving fair housing forward from the perspective of their agency. We also have a session on real estate industry, but for the home buying perspective. That one will go into things like appraisals, lending, some of those kinds of elements of discrimination that affect people that are attempting to purchase a home. We'll be looking at exclusionary zoning and then disparate impact investigations. And the closing speaker is Colette Massengale from the National Association of Realtors. She will be providing a closing keynote, and then joining a panel discussion on best practices and innovative approaches to increasing equity in housing. And following that will be a reception. As the director mentioned, the purpose of the event, and each one of these workshops will have a person in that workshop who is taking notes to keep track of the things that are discussed, and most importantly, the policy recommendations. And each of these workshops, the panelists are being informed and led to understand that the point is to end with recommendations. So we've asked them, based on their expertise, to bring some recommendations. The hearings are also providing some examples of things that can push fair housing forward. And the day of the summit itself will basically be an opportunity to kind of put various experts and people that are affected by housing discrimination issues in the same room and let them have an opportunity to sort of hash things out so that we can walk away with actionable recommendations, policy recommendations that we can use to actually accomplish some things and to move fair housing forward. The last thing I'll talk about with the summit is in terms of the targeted audiences. From previous summits, we've had people that are concerned with civil rights issues in general. We will have public servants, I was going to say elected officials, but public servants in general, not just people that are elected from state government agencies, federal government agencies, and local agencies. And in each of the summits, we also have people coming from the industry most affected by the topic of that summit. So for example, last year, the topic was discrimination and healthcare. So we had a number of healthcare organizations, health departments attending last year's summit that probably would not normally have joined a civil rights summit. In that case, in that vein, I'm also expecting people from the real estate industry that are more concerned with their industry than they are with the civil rights implications. But I think that's important because it allows for an opportunity to get people who care about civil rights and people who understand the industry in the same room for discussions that can actually lead to some kind of solutions. So I think that's the end. I was going to talk a little about the white paper, but I think the director covered that. So that's the end. Are there any questions from the commission?
Mr. Kaur, I do have one quick question or a request. In attending all the different hearings, one of the areas that kept coming up were the different housing commissions, the city housing commissions and the county housing commissions. Will there be invitations extended to all those commissions to attend the summit?
Yes, yes, we will be making recommendations to the housing commissions around the state. We actually have, well, she's not from a housing commission, but the MISTA, the State Department MISTA, a person from Detroit who handles some of the housing choice vouchers is on the closing panel, so she'll be able to talk a little about some of the solutions in terms of the programs and funding that flows through the housing commissions. So yes, we will have them invited.
Commissioners, are there any questions?
Got a comment.
Okay. Yes, Director Johnson?
Thank you, Madam Chair, for the opportunity. Just to follow up on what Mr. Kaur talked about, it's already yielded some positives and some results. I had opportunity to meet with Michael Tierney last week, president of the Community Bankers Association. They represent small banks. We talked about artificial intelligence. That's one of the topics you heard Harold talk about, and how, have you heard me talk about that, how it permeates. We see it as an emerging issue in civil rights. We talked about that in terms of lending. He said, well, it's not arrived yet, but it's coming. And he wanted us to talk to the members of his association in terms of how they can look at AI from an equity perspective. So it's already yielded results. Talked to last night's one was there from the licensing and from Laura, licensing and regulation. He's already talked again about requiring implicit bias training for the appraisers before they get licensed. So it's already yielding results in terms of a collaborative effort. We want to wind this, as Carol said, with the best practices, so we want the banks involved, the state involved, looking at policy changes, policy reform from on the public and private sector. Agencies, DIPS is involved. They already recognize that they have an obligation to get word out that you can file a complaint with them if you feel you've been a victim of credit discrimination, mortgage discrimination. So it's bringing awareness to a lot of agencies about this issue. So we're hoping to come out of this, again, with a solid set of recommendations, both on the public and private sector sides, we can push and implement.
Great. Thank you, Director Johnson. Are there any additional questions? Thank you, Mr. Kaur, for your report. We are certainly looking forward to the summit.
Thank you, Commissioners.
Remember one coming. And I want to thank Harold. And it was as appropriate if you saw his picture. Next to him was two key people working with him, Patty Barrera and Liliana Stonebeck. They've done a magnificent job of putting this conference together, and thank them for all the hard work that they've poured into this. So just want to give them a shout out. And you'll hear from Liliana in a minute, but can't ignore Patty Barrera, who's been with the agency for quite a while, and she's just transitioned into this position, has done a magnificent job for us. So thank all three of them.
Great. Thank you, Director. I was also going to extend my appreciation in my comments. So. We will now move on to the next agenda item, Fund Development Report by Liliana Stonebeck, who serves as a Fund Development Coordinator. Good morning, Ms. Stonebeck, and thank you for joining us today. We have received your written report, and you have the floor.
Thank you, Commissioner Lara. Good morning, Commissioners, and good morning, Director and General Counsel Satchel. My name is Liliana Stonebeck, and I am the Fund Development Coordinator for the department. I came to the department in the summer of 2023, rejoining after being here in the 90s under Director Reynolds. My job as the Fund Development Coordinator is to bring funds to the department from private sources, and I have been working in the last almost 9 months to steward some relationships with the department, to introduce the department and our work to different entities that might fund our work, to find alignment, and to help us prioritize our work so that we can find people who would invest in that work. I have been working, as Harold said,
on the Civil Rights Summit and the public hearings, and we have done a lot of great work behind the scenes, creating a landing page, developing the agenda, working on the workshops. We also have added a component to the summit this year. We are going to have exhibitors there. This is an excellent way to develop relationships with organizations around the state. And so we will have community organizations that might be able to provide resources outside of maybe our purview. We'll have state agencies there with exhibitor booths and all types of housing agencies and organizations that will help expand our reach, let us tell our message, and just create public awareness about the organization. I'm also working on sponsorships. To date, we have 8 sponsorships, and we have been able to get a sponsorship from one of the banks that has, with all the lending and discrimination type things, it's a long process to get people to understand our work and to be able to build those relationships, so we're excited about that. In terms of private funding, the department is able to raise about $600,000 in private funding, and this is a new area for us. We are working hard to introduce foundations and other corporate giving type programs to our work. As the director mentioned, the white paper, that's really important in this component of the work in order to align the mission and vision and the priorities of the department with the mission and vision of funding organizations. We will be having a meeting this Wednesday with the Office of Foundation Liaisons and a group of foundations to introduce the department to the foundations. Those foundations include Kellogg, Balmer, Joyce, the Ann Arbor Community Foundation, Skillman, Mott, Song, and WEG, that is from out here from Grand Rapids. The Office of Foundation Liaison is an organization that sits inside the governor's office, although it is funded by foundations, and it was created over 20 years ago to help foundations understand the priorities of state government. And so they serve kind of as a clearinghouse and a connection point between private foundations and state government. We're really excited about this meeting. This is a great opportunity for the department to really tell our story and to share the vision that we have. We're going to focus on our prevention work. Obviously, we've gotten funding for enforcement, heavy enforcement, so that we are going to be sharing all of the different initiatives that we have around prevention. And hopefully through this, foundations will learn about our work and will find different areas of alignment and collaboration. So that is a wrap-up of the Fund Development Coordinator activities, and I'm happy to be here. Thanks so much.
Great. Thank you, Ms. Stonebeck, for your report. Commissioners, are there any questions? Seeing none, we will move on to the next agenda item. Attorney General report from Assistant Attorney General Tanya Jeter. Good morning, Attorney Jeter, and thank you for joining us today. We have received your written report, and you have the floor.
Good morning. The Commission has a copy of my report, so I will update you on a few of our more high-profile matters, starting with numbers 2, 3, and 4 in my report: Christian Healthcare, Sacred Heart, and St. John's. All 3 are federal appeals challenging the constitutionality of various provisions of the Elliott Larson Civil Rights Act based on the First Amendment. As of today, all the briefing has been completed by the parties, so the matter is pending before the Sixth Circuit Court of Appeals. Next is number 5 on my report, which is Raymond Kyle versus Director Johnson. This matter arose out of an administrative appeal alleging religious discrimination. The Circuit Court has granted our motion to dismiss this matter, so at this point, we're waiting to find out if the plaintiff is going to file a delayed application for appeal. Next is number 9 on my report, which is John Isaac Harris versus the Department. This is another federal lawsuit against the Department and the Commission arising out of a decision of the Department not to proceed on the complaint. We filed a motion to dismiss in this matter. It's pending before the court for a decision. Next is numbers 10 and 11 of my report. They're correlated cases, so I'll start with number 10. The City of Grand Rapids versus the Department and the Commission. Grand Rapids essentially sued the Department, arguing that any investigation over 3 years old or more violates the Revised Judicature Act, specifically the provision in the Act that has a 3-year statute of limitations. On April 18, probably last week, I think, or maybe the week before, the Court of Claims granted our motion to dismiss in this matter, so we're waiting to find out if the plaintiff will be filing an appeal. And then next is number 11 of my report, which is Ayala versus Grand Rapids versus Ayala versus Grand Rapids and the Grand Rapids Police Department. In this case, we filed a complaint asking the Circuit Court to compel discovery in this matter. The court entered an order holding its decision in abeyance until the Court of Claims reached a decision on the Grand Rapids lawsuit. Finally, we have number 12 of my report, which is Studio 8 Hair Lab versus the Department. Again, this is another lawsuit, but this time filed in a circuit court, challenging the constitutionality of various provisions of the Elliott Larson Civil Rights Act. On March 21st, the court dismissed the complaint against the Department. On April 1st, the plaintiff filed a motion for relief from that dismissal order. On April 26th, we responded, obviously, to that motion. On April 26th, oral arguments were heard on that motion, so now we're just waiting for a decision from the Circuit Court. With that said, that concludes my report. If you have any questions, I'm happy to answer.
Thank you, Attorney Jeter, for your report. Commissioners, are there any questions?
Madam Chair.
Commissioner Worthams?
Thank you, Madam Chair. And Tanya, thank you for your report. Just to maybe close the loop in my head, going back to the Alaya versus Grand Rapids case. So the court said it was going to wait on ordering discovery until the Court of Claims had resolved the initial Grand Rapids case.
That's correct.
Now that that's been resolved, has the court ordered discovery, or do we need to go back for file another motion, or how's that work?
We're going to have to go back before the court and advise them of the outcome of the lawsuit wherein the Court of Claims granted our motion to dismiss. We haven't done so because we're waiting to find out if Grand Rapids is going to appeal. Once the appeal period runs its course, then we can go back to the Circuit Court and advise them. They can make a decision as to our motion to compel discovery.
And the rules for the deadline for the appeal is at
21 days. A delayed app is 6 months.
Oh, fine. Thank you.
Great. Thank you, Commissioner Worthams. Are there any other questions? Seeing none, we will move on to the next agenda item, Commission Business. Our first item under Commission Business is Chair's Report, and this is my first Chair's Report, so please bear with me. First of all, I would like to recognize State Representative Julie Rogers and Kalamazoo City Commissioner Jean Hess, who have joined us, and we really appreciate you joining us. Thank you so much. Second, the Fair Housing Summit. I've attended most of them, including in Flint, Grand Rapids, and the virtual one that we had a few months ago. I would like to commend the department for their really hard work on the hearings. There's a lot that goes on behind the scenes, and they all ran very smoothly. The locations were great. The support was really good. So I would like to take this time to really extend my appreciation and my congratulations for running these summits. They were all across the state, and we're looking forward to, again, a really great housing summit as well. So thank you to everyone that was involved. Second, I had the opportunity to attend a conference in Chicago put on by the University of Chicago Institute of Politics. It was called Bridging the Divide, Forging the Ties Between Rural and Urban America. And the reason I attended is, we tend to focus in Michigan on where we live, and most, the population centers are in Detroit area, Grand Rapids area, and there is really most of the counties in the state of Michigan are rural. So that was an area that I wanted to explore and come back with some thoughts and ideas. Some of the people that, some of the sessions that we had were, for example, We Are What We Eat, the urban-rural food system, just reminding us where our food comes from. And another interesting one was the power of place and particularity when we trust the virtual world over our own backyard. So that was another area where we really needed to focus on how that can affect how we view ourselves in place, whether we're in urban or rural. And let's see, the other one was that I found quite interesting, if I can find it, was what realities are we reading? Local news deserts and polarization. The panelists were Jeff Zeleny from CNN, Tim Marima, The Daily Yonder, Sylvia Rivera, director of the local news program at the MacArthur Foundation, and it was moderated by the Institute of Politics founding director David Axelrod. It's really imperative and really important that we maintain our local contacts with our news medias and having unbiased news media coverage. There are so many things that happen outside the major cities that really have an effect on how we view our local government as well as our state government. And one of the areas that I really, have spent a lot of time was in Ottawa County, where the local news media there actually pointed out and covered a lot of the issues that were happening in the political arena and the county level. That really made it very evident to the county residents as to what is going on specifically at county levels and how it affects you on a day-to-day basis. So that was an area that I think was really important, and that we need to support our local media as well as our larger media. That concludes my report. So moving on to the next order of business, committees for Commission's 2024 priorities. Last year, the Commission adopted 3 priorities for 2024, which include voting rights, diversity, equity, and inclusion, and Juvenile Justice. Committees were formed to take the lead and focus on their assigned priority and bring recommendations to the Commission regarding next steps, which may include, but are not limited to, holding special meetings, public hearings, listening sessions, inviting special guests and/or expert witnesses, and preparing studies and/or reports. Let's begin with the Voting Rights Committee, for which Vice Chair Wortham serves as chair, and Commissioner Roberson and Commissioner Corriveau serve as committee members. Vice Chair Worthams, are there currently any updates from the Voting Rights Committee?
Just a quick one, Madam Chair. While the Voting Rights Subcommittee has not met, we did that on purpose to see how the two special state House legislative elections were going to go, and how the new implementation of the extended voting opportunity period will play out in a special election format. So I expect to call a meeting of the committee together sometime later in May, once those two new representatives have been sworn in, and ideally be able to get some information from the Department of State, or at least the Board of Canvassers, just to get their reaction of how things ran. And then, of course, that prepares us for the excitement of August and November, when we'll really see how the rubber hits the road when it comes to those new statutory changes. So look forward to being able to report more on that as we go into our July meeting.
Thank you, Vice Chair Worthams, for your update. Commissioners, are there any questions? Seeing none, we thank the Voting Rights Committee for your work and update. Next, we will hear from the Chair of the Diversity, Equity, and Inclusion Committee, for which Secretary Londo serves as the Chair, and Commissioner Barker and I serve as committee members. Commissioner Londo, are there currently any updates from the DEI Committee?
Thank you, Madam Chair. I believe that you will see a resolution during new business about the use of AI in policing. Additionally, as we've heard from multiple speakers today, AI is a hot topic not just in policing, but in real estate and multiple other sort of jurisdictions. So I'll look forward to convening a meeting of that committee and figuring out how we can move the needle for other protected classes in the state of Michigan, and potentially soliciting some policy recommendations from experts in the field.
Great. Thank you, Commissioner Londo, for your update. Commissioners, are there any questions? Seeing none, we thank the Diversity, Equity, and Inclusion Committee for your work. Next, we will hear from the Chair of the Juvenile Justice Committee, for which Commissioner El Hassan serves as Chair, and Vice Chair Worthams and I serve as committee members. Commissioner El Hassan, are there currently any updates from the Juvenile Justice Committee?
Good morning, and thank you. No direct updates, but I will say that in my conversation, I think, with you, I'll just confirm on the record that it's my understanding that we will likely try to bring in someone to engage us during our educational retreat on the topic of juvenile justice, just so we sort of know what those what are we looking at and what are we looking to explore as a commission that is relevant to this body. And so that'll be really our first, I think, direct exposure to the topic.
Thank you, Commissioner El Hassan. Commissioners, are there any questions? Seeing none, we thank the Juvenile Justice Committee for your work and update. We will now move on the final commission business item, item C, date selection for the Commission's 2024 educational retreat. Just to provide some background for the audience, the Commission meets annually for an educational retreat after new commissioners have been oriented and for strategic planning purposes. Fellow Commissioners, last year our educational retreat took place in September in conjunction with a special Commission meeting. The Executive Committee met recently and decided to convene this year's educational retreat towards the end of June. The proposed date is Monday, June 24th, and an alternative date would be July 1st in Lansing. We look to convene late morning around 11 a.m. Commissioners, is there any objection or comment regarding the proposed dates for the educational retreat? And I'll wait a few minutes while you check your calendars.
Madam Chair?
Yes,
I
Commissioner
just
Roberson.
would ask, do we have any kind of estimate as to how long the educational retreat will go? I do have an evening meeting or a late afternoon meeting, so I can reschedule, but I just wanted to get an idea.
Director Johnson, do you have any thoughts as to how long these usually are? Probably till about 3 or 4?
Thank you. Probably, yes. I would anticipate probably at least 4 hours, if not 5, I would think.
Great, thank you.
Thank you.
Commissioner Roberson? Okay, thank you. Any other questions? Calendar issues? All right, seeing none, are all commissioners available on either June 24th or July 1st? We will finalize, yeah.
I'm not available July 1st.
July 1st, all right.
That's going to be difficult.
Yeah, it's
Prefer the
4th of July
24th.
week.
Right. Yes. I'd like to entertain a motion to approve the 2024 Commissioner Educational Retreat for June 24th. Is there a motion?
Madam Chair.
Commissioner Worthams,
Support.
and there is a support from Commissioner Londo. Is there any additional discussion?
Have we decided on a location?
It would be in Lansing.
Oh. Is there an option to make it virtual? It's an educational retreat. It's not
Right.
it's not commission business.
So we will discuss that with the director, but there,
Okay.
That's what we did 2 years ago.
Right.
Virtual 2 years ago.
Yeah. it
right, we
was.
did virtual 2 years ago.
Yeah, but just given the selection of Lansing, I assumed that there
Correct.
was hope that there would be attendance, so.
Right,
I
correct.
mean,
It, you know.
if it's
the-
virtual, you don't need a location then, if everybody's going to attend virtual.
Correct. We'll discuss that with the director.
That's a full day.
Perhaps having it hybrid, which is always a challenge,
Yeah.
but it's always good to be able to meet in person as well. But, you know. Is there additional discussion? So all in favor of the motion to approve the date of June 24th for the Commission Educational Retreat, say aye.
Aye.
Opposed? Motion carries unanimously, and the date for the 2024 Commission Educational Retreat is approved for June 24th. We will communicate later as to exactly how that format and location will be. Moving on to the next agenda item, new business. Commissioners, we have several new business items before us, including 4 resolutions, 2 policies, and 2 amendments. Let us start with item A, resolution condemning promotion and celebration of Great Replacement Theory. Sponsoring this resolution is Vice Chair Worthams. Vice Chair Worthams, you have the floor.
Thank you, Madam Chair, and members of the commission. Prior to reading this into the record, let me just stress that on the side, I'm a DJ. And as a DJ, I am a very big believer and defender in the First Amendment. But just because we have First Amendment rights does not necessarily mean that we are protected from the outcomes or the results or the responses to our exercise of those rights. And so the following resolution that I offer is given in the spirit of respecting other folks and their First Amendment rights, but also cautioning them on the importance of being responsible in the exercise of that right. It's a resolution in condemnation of the promotion and celebration of the Great Replacement Theory. Whereas the Michigan Civil Rights Commission is a public body established under Article 5, Section 29 of the Michigan Constitution, which vests the Commission with the power to investigate alleged discrimination against any person because of religion, race, color, or national origin in the enjoyment of the civil rights guaranteed by law and by the Constitution, and to secure the equal protection of such civil rights without such discrimination. And whereas there is a pernicious worldwide phenomenon rooted in racist notions of white supremacy that is increasingly advocated by irresponsible individuals and which is inimical to the interest of civilization, welfare of humanity, and safety of people of color. And whereas this phenomenon, popularly known as the Great Replacement Theory, espouses the existence of a global conspiracy orchestrated to systematically replacing populations of white people with people of color, and explains the immigration of people of color as a nefarious scheme calculated to undermine and replace the culture and political power of white people living in Western countries. And whereas the promotion of racist narratives, beliefs, and value systems as embodied in the Great Replacement Theory only serves to fuel intolerance, generate fear and aggression, instigate acts of violence against people of color, and impair the ability to implement rational immigration policy. And whereas the Michigan Civil Rights Commission observes that this nation was founded as a collection of immigrants, some willingly and others forcibly transplanted to a continent occupied and settled by indigenous peoples who soon became dispossessed of ancestral lands. And whereas the Michigan Civil Rights Commission observes that the rights, privileges, and expressions of liberty embodied in the Michigan Constitution, federal Constitution, and many municipal charters throughout the state of Michigan are universal in their application and not reserved for any race or ethnic group. And whereas the state of Michigan enjoys a rich cultural, racial, and ethnic diversity that reflects our commitment to tolerance, inclusiveness, and respect for racial and ethnic harmony, which adds to the social vibrancy and economic prosperity of the state of Michigan. And whereas it is incumbent on those within the state of Michigan serving in positions of leadership who are entrusted with the power to influence public policy to recognize the significance and impact of their public statements on and outside of social media, which both sets an example and directs the tone of public discourse throughout the state. And whereas public leaders can best ensure strong policy outcomes through intellectually honest debate and by eschewing, resisting, and confronting the irrational racist Great Replacement Theory and endeavoring to educate, accustom, and commit themselves to fully understanding the historical and factual record, and by deeply considering the complexities and subtleties of issues impacting the physical and psychological welfare of Michigan citizens. Now therefore be it resolved that the Michigan Civil Rights Commission condemns the promotion and celebration of the ignoble Great Replacement Theory and supports and encourages responsible executive and legislative efforts intended to challenge the endorsement and capitulation to this theory and its deleterious ramifications for the welfare of citizens of Michigan, and directs the Michigan Department of Civil Rights, where it deems feasible, to provide legislative officials and executive departments and officials with any advice or pertinent information within its control which may assist in addressing this issue and otherwise take steps to educate the public in this matter. Be it further resolved that this resolution shall be sent to Governor Gretchen Whitmer, the Speaker of the Michigan House of Representatives, and the President of the Michigan State Senate. Madam Chair, I offer this resolution and ask for another commissioner to make a motion to adopt it.
Thank you, Commissioner Worthams. I will entertain a motion to adopt the resolution. Is there, thank you, Commissioner Roberson. Is there a second?
Support. You can give it to Commissioner Barker.
Thank you, Commissioner Barker. Is there any discussion or revisions?
Discussion. Well done. That was awesome.
Thank you, Commissioner Barker. Mr. Satchel, will you please call the roll for adoption of the resolution?
Yes, Madam Chair. Commissioner Roberson.
Aye.
Commissioner El Hassan.
Support.
Commissioner Barker.
Support.
Commissioner Worthams.
Yes.
Commissioner Lara.
Support.
Commissioner Londo.
Yes.
And Commissioner Gaskell.
Yes.
Madam Chair, unanimously passes.
Thank you, Attorney Satchel. The motion carries unanimously and the resolution is adopted.
Madam Chair.
Commissioner Worthams?
May I just express my gratefulness to the Commission for adopting that resolution and to the General Counsel for his assistance in drafting it. If there's a walk-in thesaurus, that would be the man right there.
I certainly agree. Thank you. And thank you, Commissioner Worthams, for sponsoring this resolution. And thank you again, Attorney Satchel, for your assistance in preparing this resolution. Now let us move to item B, resolution on use of artificial intelligence, or AI, in policing. Sponsoring this resolution is Secretary Londo. Secretary Londo, you have the floor.
Thank you, Madam Chair. A couple days ago, I had the pleasure of attending a wedding of a very close friend, and the officiant of the wedding was the judge who had tried the case of the police officers in Minneapolis who were guilty of the murder of George Floyd, and it helped me really understand and contextualize this resolution, because as new threats tend to permeate some of our institutions, it's really incumbent on us to make sure that we are looking at these threats seriously and advocating for intelligent change so that we can continue protecting all of the protected classes within the Elliott-Larsen Civil Rights Act. So with that, I offer a resolution recommending transparency and a responsible, research-based approach in the use of artificial intelligence in policing. Whereas, the Michigan Civil Rights Commission is a public body established under Article 5, Section 29 of the Michigan Constitution, which vests the Commission with the power to investigate alleged discrimination against any person because of religion, race, color, or national origin in the enjoyment of the civil rights guaranteed by law and by the Constitution, and to secure the equal protection of such civil rights without such discrimination. And whereas, advances in technology have resulted in the increasing and pervasive use and application of artificial intelligence programs, software, and data analytics for surveillance and other law enforcement measures aimed at the prediction, investigation, and prevention of crime. And whereas, there is a well-recognized, thoroughly researched, comprehensively documented, and statistically significant amount of data evidencing bias, discrimination, and racial disparity in law enforcement as it relates to people of color. And whereas, artificial intelligence-powered policing tools have been known to be less than accurate and susceptible to exacerbate and facilitate existing law enforcement racial, national origin, and ethnic biases, or otherwise have a discriminatory impact, particularly where predictive policing tools make use of historical crime data. And whereas, law enforcement agencies in Michigan currently or may in the future employ predictive policing systems powered by artificial intelligence. And whereas, the risk and harm associated with law enforcement agencies' indiscriminate use of predicting policing tools with reliance on a veil of scientific legitimacy does not justify their uses in decisions that ultimately impact the life, safety, and liberty of Michigan citizens. And whereas, against the backdrop of our country's documented bias in law enforcement, to ignore the historic prejudice in policing practices that have resulted in inherently biased data, statistics, and actionable information is tantamount to an intentional decision to perpetuate racial, ethnic, and national origin discrimination. And whereas, the Michigan Civil Rights Commission affirmatively recognizes several United States senators and a member of the Michigan House of Representatives, including Senators Wyden, Merkley, Padilla, Welch, Fetterman, Markey, and Representative Clark, who have taken a public stand against the potential abuses of artificial intelligence in policing by urging Attorney General Garland to halt all Department of Justice grants for predictive policing systems until the DOJ can ensure that grant recipients will not use such systems in a way that has a discriminatory impact, and recommending that the DOJ, in its forthcoming presidential report on the use of artificial intelligence in law enforcement, specifically investigate predictive policing technologies, assess the accuracy and precision of predictive policing models across protected classes, their interpretability, and their validity, without any limits on assessing their risks posed by a lack of transparency from the companies developing them, and recommend whether and how law enforcement agencies can use these technologies to enhance public safety without having discriminatory impacts. And now, therefore, be it resolved that the Michigan Civil Rights Commission recommends transparency and a socially responsible, bias-free, research-based approach in the use of artificial intelligence in policing, and encourages the governor to convene a task force on artificial intelligence in policing and establish a permanent commission on artificial intelligence empowered to study, research, and advise the executive branch and the legislature in all areas related to artificial intelligence, that the Michigan legislature enact legislation that regulates the use, acquisition, and implementation of artificial intelligence in policing so as to eliminate the perpetuation of bias and discrimination, and that the Michigan Department of Attorney General consider the employment of its resources to protect the interest and welfare of Michigan citizens who may be impacted by artificial intelligence policing practices and protocols that are susceptible to bias and discrimination against protected classifications, and be it further resolved that all law enforcement agencies in the state of Michigan should review their current and future uses of artificial intelligence policing tools to determine their efficacy and tendencies to perpetuate, incorporate, or facilitate bias and discrimination, and be it finally resolved that this resolution be forwarded to Governor Gretchen Whitmer, the Speaker of the House of Michigan Representatives, President of the Michigan Senate, Michigan Department of Attorney General, Michigan Association of Police Organizations, Michigan Association of Chiefs of Police, and Michigan Commission on Law Enforcement Standards.
Thank you, Commissioner Londo. I will entertain a motion to adopt the resolution. Is there?
So moved.
Commissioner, thank you, Commissioner El Hassan. Is there a second?
Madam Chair.
Thank you, Commissioner Roberson. Is there any discussion or revisions? Seeing no hands for discussion, Mr. Satchel, will you please call the roll for adoption of the resolution?
Commissioner Roberson,
Support.
Commissioner El Hassan,
Yes.
Commissioner Barker,
Support.
Commissioner Worthams.
Yes.
Commissioner Lowry,
Support.
Commissioner Londo,
Yes.
Commissioner Gaskell.
Yes.
Madam Chair, unanimously passes.
Thank you, Attorney Satchel. The motion carries unanimously, and the resolution is adopted. Thank you, Commissioner Londo, for sponsoring this resolution, and thank you, Attorney Satchel, for your assistance in preparing this resolution. Now let us move on to item C, resolution in support of legislation facilitating the selection and declaration of gender identity. Sponsoring this resolution is Secretary Londo. Secretary Londo, you have the floor.
Thank you, Madam Chair. This resolution specifically deals with HBs 5300, 5301, 5302, and 5303, which helps facilitate the process of individuals changing their gender, or excuse me, sex on specific government documents, as well as declaring their identity. So with that, a resolution in support of legislation facilitating the official selection and declaration of identity. Whereas the Michigan Civil Rights Commission is a public body established under Article 5, Section 29 of the Michigan Constitution, which vests the commission with the power to investigate alleged discrimination against any person because of religion, race, color, or national origin in the enjoyment of the civil rights guaranteed by law and by the Constitution, and to secure the equal protection of such civil rights without such discrimination. And whereas the Michigan Elliott Larson Civil Rights Act prohibits discrimination based on sexual orientation and gender identity, and whereas LGBTQ+ citizens have the legal and moral right to the enjoyment of the privileges and opportunities afforded other citizens of Michigan, and whereas the selection and declaration of gender identity is an essential expression and exercise of a person's inherent civil and political right to life, liberty, and pursuit of happiness, and which serves as the foundation for the affirmation of being. And whereas, according to a report entitled Early Insights, a report of the 2022 U.S. Transgender Survey from the National Center for Transgender Equality, more than 20% of trans and non-binary people reported that they were discriminated against for showing documents that did not match their presentation. And whereas, according to a report entitled The Report of the 2015 U.S. Transgender Survey by the National Center for Transgender Equality, only 11% of trans individuals reported all their identifications documents had an accurate name and gender marker. And whereas, according to a report entitled Gender Marker Changes on State ID Documents, State Level Policy Impacts from the UCLA School of Law Williams Institute, 78% of transgender Michiganders lacked accurate identification due to burdensome and costly requirements for updating one's name and gender designation prior to policy changes beginning in 2019 by the Michigan Secretary of State, and whereas availing oneself of governmental privileges and opportunities to officially declare one's gender identity should not be subject to the limitations of antiquated notions of gender and sexual orientation that are inconsistent with current laws and prevailing rational sentiments. And whereas the citizens of the state of Michigan have, through the extension of the Elliott-Larsen Civil Rights Act, affirmatively recognized and protected multiple expression of gender identity and sexual orientation, and whereas certain current Michigan laws that facilitate and dictate how a person's gender identity is established for governmental and other purposes is incongruous with the civil rights law of Michigan and evolving notions of gender identity and sexual orientation. And whereas the Michigan legislature has before it several proposed bills, including House Bills 5300, 5301, 5302, and 5303 that amend laws pertaining to changing one's legal name, designation of gender on a vehicle operator's license and chauffeur's license, designation of gender on an official state personal identification card, and designation of sex on a certificate of birth, respectively. And whereas these proposed amendments are designed and intended to respect the right of self-determination and self-identification as embodied in the Elliott-Larsen Civil Rights Act and Michigan law interpreting the same, remove legal barriers and promote the inclusion and acceptance of the transgender community into the larger Michigan community of tolerant and respectful citizens. And whereas the Michigan Civil Rights Commission, in observation of and in deference to its constitutional mandate, embraces all legislative attempts to protect and facilitate the civil rights of Michigan citizens, and therefore be it resolved that the Michigan Civil Rights Commission hereby supports and recommends passage of the aforementioned legislation and that it be signed into law, and commends the Michigan legislature to the continued vigilant protection, facilitation, and expansion of civil rights for the citizens of Michigan. And it is further resolved that this resolution be provided to the sponsors of each individual bill, Speaker of the House, Speaker pro tempore, majority and minority leaders of the Michigan House of Representatives, Senate President, President pro tempore, majority and minority leaders of the Michigan Senate, and Governor Gretchen Whitmer. And Madam Chair, I move adoption.
Thank you, Commissioner Londo. And I was going to say I will entertain a motion to adopt the resolution, and you have already moved that adoption. Thank you, Commissioner Londo. Is there a second?
Second.
Thank you, Commissioner Barker. Is there any discussion or revisions?
Madam.
Laura.
Commissioner El Hassan?
Just a friendly amendment, if accepted. Given the purpose of this resolution on the Declaration of Identity, I just don't think that it's necessary to point out what the civil rights, the Elliott-Larsen Civil Rights Act prohibits discrimination based on sexual orientation and gender identity. Given that this resolution is specifically about identity and not addressing sexual orientation or changes to documentation about sexual orientation, I don't see the necessity for the reference to sexual orientation in the second whereas clause and in the 9th whereas clause and the 8th.
Yep.
Because we're not asking for that particular, for anybody to note their sexual orientation on their
absolutely.
identification.
Thank you. I accept that.
Is there any additional discussion regarding those changes? All right, I would like to entertain a motion to amend the resolution as previously stated by Commissioner El Hassan.
Motion.
Thank you, Commissioner Roberson. Is there a second?
Second.
Thank you, Commissioner Worthams. This is a vote on amending the resolution. Is that a roll call or hands?
It's the same
Voice?
motion, but as amended.
As amended.
So, yeah.
Madam Chair, may I ask also that I be given permission to correct any grammatical errors that are in the document, because there are a few grammatical errors in the document that would need to be corrected, so that I'd be given the liberty to do that as a part of finalizing the document.
Yes, the commissioners, yes.
You ready for the vote?
So, yes.
Okay.
Now, is this for the amendment or the entire resolution?
I believe Commissioner Londa has accepted the friendly amendment so that we can now vote on the motion as amended.
Thank you.
Commissioner Roberson,
Support.
Commissioner El Hassan,
Yes.
Commissioner Barker,
Support.
Commissioner Worthams,
Yes.
Commissioner Lara,
Support?
Commissioner Londo,
Yes.
and Commissioner Gaskell.
Yes.
Unanimous passage, Madam Chair.
Thank you, Attorney Satchel. The motion carries unanimously as amended, and the resolution is adopted. Thank you, Commissioner Londo, for sponsoring this resolution, and thank you, Attorney Satchel, for your assistance in preparing this resolution. Now let us move on to item D, which is the final resolution sponsored by Secretary Londo. This is a resolution in support of ban on gay panic defense. Secretary Londo, you have the floor.
Madam Chair, thank you. This is a resolution in support of the banning of the gay panic defense. Whereas the Michigan Civil Rights Commission is a public body established under Article 5, Section 29 of the Michigan Constitution, which vests the commission with the power to investigate alleged discrimination against any person because of religion, race, color, or national origin, and the enjoyment of the civil rights guaranteed by law and by the Constitution, and to secure the equal protection of such civil rights without such discrimination. And whereas the Michigan Elliott Larson Civil Rights Act prohibits discrimination based on sexual orientation and gender identity, and whereas the right of LGBTQ+ citizens to enjoy the same rights and privileges as other citizens of Michigan and to feel safe and secure in their person is of paramount importance, and whereas there exists an historic legal defense grounded in irrational fear and prejudice towards the LGBTQ+ community, commonly known as the gay panic defense, which is based on the morally offensive notion and repugnant implication that violent conduct towards individuals based on their sexual orientation and gender expression can be excused and accepted under certain circumstances. And whereas the gay panic defense has been used to excuse the most heinous crimes and reduce charges for crimes of violence committed against LGBTQ+ individuals based on their gender expression and or sexual orientation, and whereas there is a groundswell of individuals and organizations in support of state and federal bans on the use of the gay panic defense, including the LGBTQ+ bar, which notes that invocation of this defense, quote, reinforces the dangerous and discredited belief that LGBTQ+ lives are worth less than others, end quote, and that the American Bar Association, which issued a unanimous resolution as early as 2013 that called on, quote, federal, tribal, state, local, and territorial governments, end quote, to forbid the use of the gay panic defense, and whereas to date only a total of 17 states have taken affirmative steps to ban the use of the gay panic defense, and whereas based on current statistics, approximately 56% of the LGBTQ+ population lives in states that do not prohibit the use of legal defenses that claim a victim's sexual orientation and or gender identity contributed to the defendant's illegal conduct, and whereas the Michigan Civil Rights Commission has historically and consistently acknowledged that the people of the state of Michigan have recognized the inherent value and dignity of its citizens and the need to protect the diversity of our citizenry through adoption of Article 1, Section 2, and Article 5, Section 29 of the Michigan Constitution, and the enactment and subsequent expansion of the protections provided under the Elliott Larson Civil Rights Act, and whereas the Michigan judicial and legislative branches of state government have acknowledged the right of an individual to be protected from discrimination based on their gender identity and sexual orientation, in that the Michigan State Legislature enacted an amendment to the Elliott-Larsen Civil Rights Act, which supports the inherent right of citizens to name and express their sexual orientation and gender identity and prohibits discrimination and harassment based on these protected classifications. And in Rocheworld LLC versus Department of Civil Rights, the Michigan Supreme Court affirmed the conclusion reached by the Michigan Civil Rights Commission in Interpretive Statement 2018-1, finding that discrimination on the basis of sexual orientation necessarily constitutes discrimination because of sex and is a violation of the Elliott-Larsen Civil Rights Act. And whereas these unequivocal expressions and declarations affirming the inherent dignity of LGBTQ+ people serve as foundational principles against attempts to sanction, excuse, or facilitate violence based on sexual orientation or gender identity, as evinced by the gay panic defense, and whereas the lives of LGBTQ+ Michiganders have value, and they are deserving of support and continued protection from assaults on their dignity and humanity through violence or sanction, and therefore be it resolved that the Michigan Civil Rights Commission supports legislative efforts to ban the gay panic defense, including House Bill 4718, and executive and judicial actions directed at eliminating this pernicious practice, in addition to responsible organized efforts to expose its detrimental impact. And it is further resolved that this resolution be provided to the Speaker of the House, Speaker pro tempore, majority and minority leaders of the Michigan House of Representatives, Senate President pro tempore, majority and minority leaders of the Michigan Senate, and Governor Gretchen Whitmer.
Thank you, Commissioner Londo. I will entertain a motion to adopt the resolution. Is there a motion?
Motion.
Thank you, Commissioner Roberson. Is there a second?
Second.
Thank you, Commissioner Barker. Is there any discussion or revisions?
Madam Chair,
Commissioner Londo?
I'd like to use this opportunity to thank Attorney Satchel for the 3 resolutions that I have offered today, for his diligent writing, expert thesaurus use, and collaborating with me to help promote these resolutions.
Thank you, Commissioner Londo. Are there any other commissioners who wish to have a discussion or comments? No? Seeing no hands for resolution, Mr. Satchel, will you please call the roll for adoption of the resolution?
Commissioner Gasco.
Yes.
Commissioner Londo.
Yes.
Commissioner Lara.
Support.
Commissioner Worthams.
Yes.
Commissioner Barker.
Support.
Commissioner El Hassan.
Yes.
And Commissioner Roberson.
Support.
Madam Chair, unanimously passes.
Thank you, Attorney Satchel. The motion carries unanimously and the resolution is adopted. Thank you, Commissioner Londo, for sponsoring this resolution, and many thanks to Attorney Satchel for your assistance in preparing this resolution and all the other resolutions. Now let us move on to item E, proposed commission policy on presentation and adoption of resolutions. I have asked staff to prepare a policy on the presentation and adoption of resolutions by the commission. The purpose of the policy is to streamline the process for preparing and presenting resolutions. For those of you who may need a minute to reacquaint yourself with the policy, please do so. Then I will entertain a motion to adopt the policy.
I'll make a motion to adopt the policy.
Okay, I will entertain a motion to adopt the policy on presentation and adoption of resolutions. And Commissioner El Hassan, you made the motion?
Yes.
Thank you, Commissioner El Hassan. Is there a second?
Support.
Thank you, Commissioner Worthams. Is there any discussion or revisions? Seeing no hands for discussion, Mr. Satchel, will you please call the roll for adoption of the policy on presentation and adoption of resolution?
Commissioner Gasco.
Yes.
Commissioner Londo.
Yes.
Commissioner Lara.
Yes.
Commissioner Worthams.
Yes.
Commissioner Barker.
Support.
Commissioner El Hassan.
Yes.
And Commissioner Roberson.
Yes.
Madam Chair, unanimously passes.
Thank you, Attorney Satchel. The motion carries unanimously and the policy is adopted. Thank you, Attorney Satchel, for your assistance in preparing this policy. Now let us move on to item F, proposed commission policy on amicus curiae briefs. Staff has prepared a policy addressing the commission's involvement in amicus curiae briefs. From time to time, it may be appropriate for the commission to consider weighing in on a civil rights matter pending before a court, and policy guidelines are necessary to assist us in that process. Attorney Satchel, can you briefly provide us the highlights of this policy?
Yes, Madam Chair. Madam Chair, this policy merely codifies a current practice that the Commission has with respect to its participation in either filing or joining. And I can't at this moment let my 3 years of Latin in college go to waste. Amicus curiae brief, although the other pronunciation is acceptable. This policy also has been shared with the AG's office, and in fact, I pulled heavily from a policy and a practice that they have with respect to the filing of amicus briefs. And for the non-lawyers in the room, what this basically is, amicus means friend and curiae means court. This is a process by which a group, usually a group, is allowed to intervene in a case that is not a party to, either to provide the court some level of expertise that that group may have or interest that the group may have in the outcome of the decision. This commission has historically done that, and it's my understanding in the past, maybe a couple years, has done this twice. So this merely sets forth codified that process in the policy for doing so going forward. And it also incorporates, as I said, the involvement of the AG's office in this, because there may be an instance, as I was advised, as I talked about this with the AG's office, where the AG's office may have taken a position on a civil rights issue that may be at odds or different from what the commission wants to do. So in that case, their review of it for that purpose is necessary. Lastly, Madam Chair and Commissioners, there is appended to this is a form. This is a form that draws heavily from a form that is used by the AG's office when they determine whether or not they're going to be involved in a amicus brief. This is a form. The reason why I use this form and at their suggestion is because since it's going to go to them, they'll be familiar with this format and the things that are necessary for them to evaluate how to put together that brief. It's already here, so to make it easier for them to do so. And it'll also help streamline the process for us and help us to think through what are the bases for us following the amicus brief. Lastly, I would add that this also deals with joining an amicus brief. There are certain situations where we may not be the author of it, but someone may come to us, or a group of organizations may ask us to sign on to an amicus brief, and we're just reviewing it to make sure it's consistent with our philosophy and our practices, and we would then sign off on it, and again, it would go to the AG's office for their review also, Madam Chair. Thank you.
Thank you, Attorney Satchel. I will now entertain a motion to adopt the policy on amicus curiae briefs. Is there a motion?
Madam Chair.
Thank you, Commissioner Worthams.
Support.
Thank you, Commissioner Londo, for the support. Is there any discussion or revisions?
Madam Chair.
Commissioner Worthams?
Thank you, Madam Chair. So in my real-world job, when I'm not DJing, I actually run the amicus program for the Michigan Manufacturers Association. And I take note, and I don't know if you've got a spy in our organization or not, Lamont, but this looks like my form. So I'm glad to know that we're kind of in the same line here as far as the information needed to make the determination of whether or not to provide an amicus brief or not. Anytime you get a chance to submit an amicus brief, I think in some cases it's helpful to just bring out those items or issues that the initial parties may not have thought of, may not have brought in their arguments. And I've been proud to be a part of a number of amicus briefs, and so I think this policy makes a lot of sense. I'm glad that we have it here, and I don't know if it means we're going to start being more friendly to the court or not. If so, more power to you. But I definitely appreciate this policy. Thank you, Madam Chair.
Great. Thank you, Commissioner Worthams. Is there additional discussion or revisions? Seeing no additional hands for discussion, Mr. Satchel, will you please call the roll for adoption of the policy?
Commissioner Gasco,
Yes.
Commissioner Londo,
Yes.
Commissioner Lara,
Yes.
Commissioner Worthams,
Yes.
Commissioner Barker,
Support?
Commissioner El Hassan,
Yes.
and Commissioner Roberson.
Yes.
Passes unanimously.
Thank you, Attorney Satchel. The motion carries unanimously and the policy is adopted. And thank you, Attorney Satchel, for your assistance and education in preparing this policy. Now let us move on to item G, approval or adoption of commission rules amendments. Staff has prepared a set of proposed amendments to the commission's rules that require the commission to adopt before the administrative rule adoption process can proceed. You have in your packet a memorandum which explains the reason for each proposed amendment and an actual copy of the amendment rules. However, I read the actual copy of the amended rules before I realized that there was a memorandum, so that was interesting. Since we have had a chance to review these documents, I will ask Attorney Satchel to briefly discuss this matter and answer any questions before I entertain a motion to adopt the proposed rules. Mr. Satchel, you have the floor.
Thank you, Madam Chair. As I mentioned in my earlier report, this document is a culmination of work that was done internally by several individuals within the department to take another look at our rules in light of other policies and practices that we have in place. As a result of that, we made a number of changes to the commission rules. The majority of them are grammatical. Each of the changes are a reference in the memo that discusses the basis for those changes. I would like to highlight maybe three things with respect to the changes that were made. One is that one of the things that we did in the rules is there are a number of places in the rules where the commission either receives or provides notice. And so what we've done, because this process can take up to a year, even if it's one or two changes, because of the process that the commission would have to go through. So what we did was we added language in your catch-all that would allow the commission to serve notice by any means that then available to us. For instance, when these rules were passed, emails were not out, and in order for us to use email as a system for sending notices, the rules would had to have been adopted. So this allows us to take advantage in the future of any changes in terms of how notice can be provided. The other thing is, I would add is Rule 3712 under hearing. This commission has the right to initiate a hearing irrespective of whether or not someone has filed a complaint. So this commission can, on its own, determine that there is what it believes to be actionable discrimination that needs to be investigated and the hearing needs to be conducted on. And so that is made clear in the current rule. But what we added was language that would allow this commission to do the same with respect to retaliation, because there are instances where retaliation may occur against someone who, or a group of individuals who may not have filed a complaint, or it may be actionable where no one has filed a complaint. So we made it clear that in those instances, this commission has the ability to hold a hearing with respect to that. The other thing is, currently in Rule 3716, which deals with orders that the commission may issue, there was language in there that requires the commission to have physical copies of all of its orders at each location, which was not the practice within the department. One of the things we added here was that we've given the commission the opportunity and the right to electronically provide those orders online so that people can have access to them. And in fact, if you recall, as I think a couple meetings ago, our last meeting, the director indicated that in the white papers being produced by the department, that one of the things we're looking at is how do we digitize a lot of the documents and information that the commission has to not only facilitate public access to it, but even assist the commission in its work. This would greatly assist the commission in its work if it had online its prior order so that it can, as it made its decisions, it can look at prior precedent and rulings that it has made on issues to help guide it in its decision-making. Lastly, Rule 3732, which is a new rule that we added. Currently in the administrative code, which is probably archaic to most of us here, probably with the exception of a few of you, I won't say who are aware of this, but the general public doesn't know about this. And buried in that code is a right that the commission has to provide notices to individuals, organizations, and groups with respect to complying with certain civil rights laws. So these are certain postings that it can do. It's buried there and it's in no other place. We thought it was well advised to pull that out and to put it into the commission rules so that the individuals, attorneys, organizations who may have some reason to read our rules or be subject to those rules will know that we have that right and that power to issue those postings of those notices. Madam Chair, unless there's any questions with respect to this, we would ask that the department would ask that the commission adopt these rules. Once adopted, that would allow us to move forward in the administrative process to finally get them approved through the formal channels and then bring it back to you for final adoption.
Great. Thank you, Attorney Satchel. I will now entertain a motion to adopt the proposed amendments to the Commission's rules. Is there a motion?
So moved.
Thank you, Commissioner El Hassan. Is there a second?
Support.
Thank you, Commissioner Worthams. Is there any discussion or revisions? Seeing no hands for discussion, Mr. Satchel, will you please call the roll for adoption of the proposed amended rules?
Yes. Commissioner Gasco,
Yes.
Commissioner Londo,
Yes.
Commissioner Lara,
Yes.
Commissioner Worthams,
Yes.
Commissioner Barker,
Support.
Commissioner El Hassan,
Support.
and Commissioner Roberson.
Support.
Unanimously passes, Madam Chair.
Thank you, Attorney Satchel, and thank you for your work on this. The motion carries unanimously, and the proposed amended rules are adopted. So thank you again and thank you, Attorney Satchel, and your staff for your assistance in preparing these proposed amended rules. Now, let us move on to our final new business item. Item H, amendment to ELCRA to allow for virtual meetings. The department has proposed that the commission pursue a legislative amendment to ELCRA that would allow for the commission to conduct virtual meetings. Attorney Satchel, can you please present this matter to the commission? You have the floor.
Thank you, Madam Chair. Madam Chair, Commissioners, as you recall in my earlier report, I referenced this amendment and read significant parts of my memo into the record because of the importance of what's being asked here. So I will not do that again. What I will do for the benefit of the commission and the public is to read into the record the amendment that's being sought with respect to the Elliott Larson Civil Rights Act in relationship to the commission being able to hold virtual meetings. Currently, MCL 37.2601 subsection 4 contains a requirement that the commission abide by the Open Meetings Act. And we've made a revision to that section that would allow for this commission to not only have virtual meetings, but also have commissioners participate in a meeting virtually. In the instance, for instance, that the commission wants to hold a physical meeting, but certain members would like to participate virtually, they would be able to do so. And so I'll read the language in the amendment. It currently reads, "The business which the commission may perform shall be conducted at a public meeting of the commission held in compliance with Act Number 267 of the Public Acts of 1976, being Sections 15.261 to 15.275 of the Michigan compiled laws. This is added. However, the Commission may convene a meeting, and members of the Commission may attend and participate in a meeting of the Commission by the use of telecommunication or other electronic or digital equipment. That's the new language. Then it ends, public notice of the time, date, and place of the meeting shall be given in the manner required by Act Number 267 of the Public Acts of 1976. I would add, too, that we added language in here that would also not only allow for virtual meetings electronically, but even over the phone, if we still have them at that time. You'll be able to use the phone also for members to participate in the meeting.
What is that? What's a phone?
My mother told me about them. I couldn't get it. But I would also add that, so we've also, in the past, we've had commissioners participate digitally or virtually in meetings. The only difference is now you can only discuss matters, but you can't vote on them. So you can influence the vote through your discussion, but you just can't vote on it. This would allow you to avail yourself of all of the rights and privileges that a member would have who was in person. Thank you, Madam Chair.
I have a few questions.
Thank you, Attorney Satchel. I will now entertain a motion to request a legislative amendment to ALCRA to allow for the Commission to conduct its meetings virtually. Is there a motion?
Motion.
Thank you, Commissioner Gaskell. Is there a second?
Support.
Thank you, Commissioner Roberson. Is there any discussion or revisions?
Madam Chair?
Commissioner El Hassan?
Just a couple questions. One, I presume participate means the ability to vote as defined in the Act?
Yes.
Okay. And is there a requirement that there be a majority of commissioners in person in attendance? Is there any sort of discussion or question or inquiry about how many are we talking about? So we hold a public meeting and we have one commissioner present and the remaining commissioners are virtual. Is that going to present an issue? Or has that come up as part of the language that you're looking to revise?
Through the chair. So the language that I added tracks language that is currently in legislation that deals with the other bodies that I mentioned. And I've had the opportunity, I should have mentioned this, I had the opportunity to talk through this with the AG's office in terms of making sure we got this right. But it does allow for that. So there's no issue with respect to how you get your quorum. So you can get your quorum through all of you being there virtually or some being virtual, some being in person, as long as you have collectively a quorum, the meeting can proceed.
Thank you. And finally, what's the likelihood of this being incorporated?
Well, it's very interesting because it has been afforded other commissions and boards, even agricultural boards or groups, right? And to me, if there's anyone who has a very good argument with respect to why it should be allowed, to me, it's the Civil Rights Commission because of the scope and the nature of the work that you do, which is statewide. It's not limited to a certain section of the state or certain industry within the state. So it's our hope that we will be able to get this passed. We currently have some amendments to ELCRA that are before Senator Geis, and so these will just be added to that. And it's our expectation that we will receive a more than warm welcome in doing this.
Thank you.
Thank you.
Is there any additional discussion?
Madam Chair.
Commissioner Londo?
Is there, similar to Commissioner Al-Hassan's vein of questioning, is there a requirement for a commissioner to physically be located in the state of Michigan? Because I know during COVID-19, for local electeds, if they were not present, I believe they needed to be physically within city limits, and then for other instances, they needed to at least be located in the state of Michigan. Would that apply here, or could I be in Aruba?
That's a good question.
Any plans on going to Aruba?
It's nice this time of year.
That is a good question. I'll have to research that. I don't know that it would make a difference where the person was as long as they were participating virtually, but
Yeah.
I will be certain to follow up on that and get an answer back to you.
Thank you.
Thanks for the
Is
curveball.
there any additional comments, or?
Madam Chair.
Yes, Commissioner Worthams?
I gotta tell you, I'm torn on this, because I understand, having lived through COVID, how important it is that we make the most of technology when it's available and when it can ease the members of the commission in accomplishing the duties that we have. And arguably, it will increase our transparency as well. Where I'm torn is in those parts of the state where you may not have access to Wi-Fi, you may not have access to high-speed internet, and it may become more challenging to plug into our meetings if we do more of them virtually. And I look at the fact that we are the only entity of the executive branch established in the Constitution itself. It puts us at the same level, maybe this sounds a little egotistical, as our brothers and sisters in the House and the Senate. The House and the Senate are allowing virtual meetings, but they're not allowed to vote virtually. They actually have to be there in person if they're going to cast a vote. They can participate in the meeting virtually, they can ask questions, they can share their opinions with their colleagues, but if they're actually going to vote in a committee, they have to be present. And even, and I think Commissioner Londo touched upon this as well, even if you're going to try to cast a vote, and that's got to be in the state of Michigan, because the governor can only act as governor when she's in the boundaries of the state of Michigan. Otherwise, she has to pass the gavel to the LG or the AG or the Secretary of State, depending where they are in the order of succession. And so I'm torn on the need to make sure that we're here physically to see each other, maybe look each other in the eye as we're having debates and as we're casting votes, but also to try to do this, as effectively and as easy as we can when there are times where you cannot be present. And so I'm leaning, I will vote to approve this moving forward because I believe in the legislative process, and I think some of that will work its way through, work its way out in the legislative process. But I just wanted to share with you that I find myself torn on what is the best course of action, what is the best policy here when it comes to virtual meetings. Thank you.
Commissioner Roberson?
I guess my thought is, in listening to Commissioner Worthams, I somewhat agree that in the last few years, I think that the ability to move around the state and have folks who genuinely and generally think that perhaps at one point the Civil Rights Commission was only for Southeast Detroit to really participate. So I guess, Attorney Satchel, my question would be for you, even if the option is provided for us, internally as a commission, are we able to designate that at least our commission meetings are done in person? Are we able to make some structure around it after this has perhaps passed?
So, thank you, through the chair. It's funny because I grappled with this issue when I was writing this and in my discussions with the AG's office, and sort of came up with the solution, because my concern was, while technology is pervasive, that's only because I believe it's pervasive, not necessarily because it is. And there are communities in the state that may not have access to, right? And so what I thought was, okay, well, look, if that's the case now, right? They don't have it, they wouldn't get it, whether we in public or did it virtually, number one. Number two, I said, well, what we could do is this. You could have a meeting in a community, right? They say they didn't have that type of access. Have it physically there, so you have a setup there, right? That would allow the commission to be projected there, or maybe some commissioners to be there, so the individuals who wanted to participate, come and speak before the commission, had a physical venue to do so, even though the majority, some of the commissioners were participating electronically. You still had a physical presence in that community. So if we want to have a meeting in, name someplace, I don't know. It's right, that may not have that type of access, you can still have it up there, right? Have a physical presence there, set up the meeting, have the setup where people can come and speak, give their testimony or public comment or whatever, and one or more commissioners, or maybe none, can be there, but you still have the physical presence, they can participate. But that was a concern of mine in terms of what happens with people who cannot participate because they don't have the means to do so.
Madam Chair. So I
Commissioner
guess
Robertson.
the only other question I would have, because I know this has come up in the past, is the cost or the tax on the budget of the department, because we still, as I believe it to be, don't have a separate budget for the commission. So are we talking an increased cost if we are providing, or is that the cost we already incur as we host meetings across the state and then still have some opportunity for people to participate virtually? I just want to be cognizant of cost as well and what it does to the department.
Yes. Director?
Thank you, Commissioner. Through the chair, it is almost kind of a cost we're incurring anyway. If there's a request for an accommodation, we accommodate, and that sometimes does entail virtual meetings. So I would not let that be an obstacle to your vote, quite frankly.
Thank you.
Is there additional discussion, comments? Take a point of personal privilege. I also am a little bit conflicted about this. Being located physically on the west side of the state, it's fairly easy for me to travel to Lansing, sometimes getting to Detroit just for the day can be a bit of a challenge, only because, trying to leave early and then come back late. But my daughter is getting married in a couple weeks here in Grand Rapids, but we do have relatives on the West Coast who are unable to attend, particularly my 94-year-old father who doesn't travel anymore. So the way that they're participating is we will be having a live Zoom venue, a live Zoom for the meeting, for the wedding. And so that's being done for the convenience and the lack of transportation or the lack of being able to travel. So again, I am a bit conflicted because I think one of the great things about this commission is that it represents the entire state of Michigan. And I do recall in our meeting last summer when we went across the Mackinac Bridge to the Upper Peninsula, that there were some commissioners that had really not been to the UP before. And I think it's important that we make every possible effort to attend the meetings in person. However, I do realize having the option of being able to participate virtually is also really important to the citizens and the residents of the state of Michigan. So those are some of my thoughts and comments. I would prefer that we all meet in person whenever possible, but realizing that there's times when it would be difficult for an individual commissioner to travel to the location.
Madam Chair, if I may, just to make sure I answered Commissioner Robertson's question, the answer to your question is yes. If you did adopt this, you could adapt it to whatever you want. So you can say, we'll have 3 meetings virtually, however many meetings, we're going to do these virtually, we're going to do these in person. So it could be.
Yeah, the statute isn't mandating virtual, it's just allowing the
Right.
option.
Right, so you
I think
could.
that's what I wanted to make sure.
Yes.
So thank you for that. Yep.
And I do have a question for you, Attorney Satchel. Right now, we are currently scheduling 4 meetings a year. So if we were to pass this and a situation came up where we needed to have an emergency meeting, that would allow us to have, give proper notice, but have the emergency meeting virtually.
Yes, yes. You would still have to abide by the 18-hour rule, but you would be able to do it virtually, which would make it a lot easier since it's at the last minute, yes.
Thank you. Any other thoughts or comments? Mr. Satchel, will you please call the roll for adoption of the motion to request a legislative amendment to ELCRA to allow for the commission to conduct its meetings virtually?
Madam Chair, I don't know, did someone move adoption?
I thought there was
yeah.
I made the
motion
motion.
and
It was
a
seconded.
second.
Okay.
Yeah.
Yes.
Okay. Commissioner Robertson?
Support.
Commissioner El Hassan?
Yes.
Commissioner Barker?
Support.
Commissioner Worthams?
Yes.
Commissioner Lara?
Support.
Commissioner Londo,
Yes.
Commissioner Gasco.
Yes.
Unanimously passes.
Thank you, Attorney Satchel. The motion carries unanimously and the policy is adopted. Thank you, Executive Director Johnson and Attorney Satchel, for your foresight in pursuing this legislative amendment, which is certain to greatly assist the work of this commission. Does anyone have any additional new business you'd like to bring to our attention? Thank you, and this concludes the new business portion of the meeting. And I believe that we do not have any additional public comment. However, I would like to recognize some additional guests that we have here today. Tanya Hewitt-Smith from the City of Kalamazoo DEI. Thank you. And Lal Tulangi, also from the City of Kalamazoo DEI. Thank you both for being here. Our next agenda item is Commissioner closing comments. My fellow commissioners, are there any closing comments before we adjourn? Commissioner Worthams?
Thank you, Madam Chair, and let me officially, I kind of unofficially did this before, but let me officially welcome you to my hometown of Kalamazoo, Michigan, and to my alma mater of Western Michigan University. Go Broncos. I also want to thank our friends here at Western for hosting the commission meeting today, and give my special thanks to University President Edward Montgomery, to the Vice President of Government Affairs, Jeff Brenneman, and their entire team for all their helps with the logistics going in today. Really do appreciate that. Once again, I want to recognize my good friend and City Commissioner, Vice Mayor Gene Hess, who has joined us today. And really let me thank you for your servant leadership, which has been an example for me to follow, and I'm doing my best to try to emulate that. Even if it has me come up with some strange words that I may not use every day in resolutions that I read. I want to give congratulations to our staff for the great work that you've done in the early parts of the legislative process when it comes to the adoption of the governor's budget. And yes, I know that our friends in some House subcommittees have gone astray. But that always happens. Either it's the House that goes astray or it's the Senate that goes astray. When they both go astray, then we know we have a problem. But typically, you know, it's one or the other, and it's an early step. And I fully expect that as the process continues and the chambers pass their respective versions of the budget and we get into conference, we will have more opportunities to remind them of the great work that this team does. The plan that the director has pulled together that I think is really coming to fruition in addressing the backlog of cases that we had when I came on the board with this commission, and I really look forward to seeing how it continues to bear very positive fruit in the future. You may have noticed that campus seems a little empty. It's because graduation was this last weekend, and I want to say congratulations to the over 1,500 bachelor degrees, 400 master's degrees, and 110 new PhDs that received their degrees this Saturday from 39 different countries. That just shows you how great this university is. And so rather than scaring you by finishing my comments by singing the fight song, I will save that for the next Western football or hockey game. I invite you to come to our next football or hockey game, especially if you can catch something at Lawson Ice Arena. And I will just say one more time, go Broncos. Thank you.
Thank you, Commissioner Worthams. Our commissioners, any other commissioners would like to make any closing comments?
I mean, who can match that?
I know.
I think that's a good way to close out.
Great. Thank you so much. So now we now move on to our final agenda item, adjournment. As we adjourn this meeting of the Michigan Civil Rights Commission, please note that our next meeting will convene on Monday, July 22nd, 2024 in Escanaba at a time and location to be determined. Is there a motion to adjourn this meeting?
Madam Chair.
Commissioner Worthams. A motion has been made by Commissioner Worthams. Is there a second?
Support.
We have support from Commissioner Roberson. All in favor of adjournment, say aye. Opposed? The motion to adjourn carries unanimously, and the meeting of the Michigan Civil Rights Commission is adjourned. The time is 12:19. Thank you, everyone, and have a great day.
You can't resist, I know.